You do not want to give your house away with a lifetime deed. In the next 3 minutes, I'm going to tell you why you don't want to give your house to your children or anybody else during your lifetime and what to do instead to avoid taxes and probate. If you have questions about estate planning, leave a comment or send me a private message and I'll get you an answer. For those of you that don't know me, my name is Gary DeWitt. I'm the founder of DeWitt Law, and I've helped thousands of individuals and families create effective estate plans to eliminate probate and more legal problems. In the next 3 minutes, I'm going to tell you why you do not want to give your house away to your children or anybody else during your lifetime and what to do instead to avoid taxes and probate. What I mean by a lifetime deed is a quitclaim or a warranty deed. In just a minute, I'll explain another type of deed that works much better for meeting your goals. If you do not want to load your children up on capital gains tax, then don't give them the house with a lifetime deed. There are other issues you may not have considered when you do this. If you need Medicaid within 5 years of the gift, then Medicaid will deny the application because you made a gift of your home. The denial will be in the form of what's called a penalty period. During this period, you will have to pay out of pocket or your family will have to pay for your care to the nursing home. The second reason you don't want to give away your house during your lifetime is taxes. If you don't want to load your children up on capital gains tax, then don't give them the house with a lifetime deed. There are other issues. When you give your house to your children, capital gains tax is calculated based on what you paid for the house originally, not what it was worth the day of the gift. For example, you buy a house for $100,000. On the day of the gift, it's worth $200,000, and on the day you pass away and the house is inherited, it's worth $300,000. Your children will pay capital gains not on the $300,000 basis, but on the basis of $300,000 less $100,000 for capital gains paid on $200,000. If you use a different type of deed instead, they would pay little to no capital gains tax. Third, your children can have you legally evicted because it is not your house. Fourth, their financial problems become your financial problems. Every other driver on the street is now a possible lawsuit that your house can be used to pay for. Your children's credit issues, their IRS issues, medical bills, credit cards, and more become your problems. The house becomes an asset that can be used or a lien placed against to pay for their problems. Fifth and finally, it is difficult to impossible to change this type of deed. If you change your mind later, then the child or children or whoever you put on the deed have to sign the new deed. I have seen it more than once where they refuse. The solution to this problem is straightforward. I can write a type of deed known as a beneficiary deed in Arkansas. This deed lets you give the house to who you want during your lifetime and keep lifetime control. Your children will save on taxes. Their problems do not become your problems. You don't run into as many Medicaid issues, and you can change this deed anytime you want without their signatures. If you have questions about estate planning, leave a comment or send me a private message and I'll get you an answer.